to everyone. But before I begin on that, some acknowledgements. So before I really begin on my topic by itself, some acknowledgements, and just like Naresh Bhai highlighted that his encouragement into indirect tax is from one session of Mr. Krishnan. I would say that applies to me as well. And I always look upon Mr. Krishnan as my mentor. And that's why it was really heartening to receive a memento from him. And I would always be very thankful to the chamber for this type of a coincidence. And I know it's a good opportunity to speak after him. And I would really be very honored by that. So, yeah, challenge also. So actually, if you look at GST, it's both a combination of opportunities and challenges. And that's what we are going to broadly talk about.
Challenge started, sir.
With a slight background, let's now move into the topic which has been allotted to me. As was being talked about in the break, people were saying that yes, good background has been created. We have a discussion of constitutional amendment bill, and now the ball is set to go into the next zone and understand what exactly is GST all about. And that's why you can see two dates here. One is the current date, and one is the date, the much talked about date of 1st of April. And you'll see that there's no year mentioned here. And that's why many a times, you know, there has been even when we go to industry forums, there has been always a bit of skepticism. GST aa raha hai kya? And even in, before this session, I'm sure quite a few of you are really still in questions ki aa raha hai kya and kab se aa raha hai? I think the answer to the first question is the writing is on the wall. The amendment bill and everything makes it very clear that we are on a path of an irreversible reform. And let's not underplay the reform. I would believe this is a reform which is the first and the most largest reform post-independence. I would think that the way we are looking at it, perhaps we might at some point of time, there are lots of hitches and clutches which Mr. Krishnan has rightly pointed out, the credit, whether it's going to be seamless, whether the network will flow nicely, all those concerns are there. But all said and done, it's a big achievement when we are trying to reduce 17 indirect taxes into 2 indirect taxes, and which also on a similar type of a base. So it's a big achievement, it's a big reform as far as the country is concerned, and as professionals, for us, I think it's an important opportunity as well as a challenge. So in that sense, 1st April, whether 17 or not, or maybe a few months here or there, we don't know. But looking at the speed which the government is moving, we might be in for a surprise and we might see it happening on 1st of April 2017. And every day, my conviction that we are closer towards 1st April is increasing. And you know, like even a couple of days back, there's a talk that we might really see an advancement of the parliamentary session in the winter to make sure that the GST bill gets enacted. The GST Council, as we know, is already formed. They are meeting sometime next week. And therefore, it's important that all of us really take this opportunity, try to understand the concepts, and then percolate it down to the clients with a major reform which we are talking about. So let's quickly look at what ideally should be the tax regime. And that's where we said that yes, when you look at the current tax regime, all of us have faced a lot of brunt on it. We have made seminars, understanding. When I started my practice, I started with the concept of works contract. And my first talk on indirect tax was on works contract. And till today I keep on talking on works contract. And I don't think I've learned anything over so many years. It's equally complex. So you know, you have a selective taxation regime. You have a tax on sale, you have a tax on manufacture, you have a deemed sale, you have a concept called declared service. And we had a very interesting example which Mr. Krishnan took, that a supply should be made for you and not against you. We have an example wherein today in declared service we have agreeing to do an act or tolerate an act and those types of things. So when you have so many taxes, the assessee gets confused of which is the correct tax to be applied, and whatever tax he applies, there's another government sitting at the back of him and expecting some another tax. And therefore, it was a law, we had not a law, I would say, a plethora of laws and plethora of implementing agencies, all of them trying to look at the same common type of an access. And that's where we had challenges over there, and a decade ago we tried to start something new. We said let's start a journey towards something which is simpler, and we looked at international perspectives, and internationally we said we have a single tax which is applicable on all supplies. Do not go into the concept of what amounts to manufacture, don't go into understanding what amounts to sale, and then don't go into too much of technicalities of each of these words. Moment there's a supply, there's an invoice which you raise, there's money exchanging hands, demand a tax which can be a uniform type of a tax, a simple rate tax regime, give unrestricted credits, and that's going to be the key in the entire GST regime as well, and have automated processes so that things happen automatically and there are self-policing and there's less dependence on bureaucracy. So that was the international perspective. So with that we started, but as we move forward, all of us are aware, because of the federal structure, we could not end up in a situation of states losing or willing to forego their autonomy. Also, there were revenue concerns, and therefore the state said we cannot actually have a situation of a singular GST in India. That's where we ultimately lived with, as a grand compromise, lived with this concept called dual GST. What does dual GST mean? It means everything else is what we talk about internationally. The tax would still be comprehensive. It would still be on all the supplies. We still don't go into now saying what is sale, what is manufacture, what is service. Moment you raise and supply invoice, there will be a GST. But instead of a GST, you will have two GSTs. So there will be a dual GST. One layer for the central government known as CGST, one layer for the state government known as SGST. And once you bring in states, there are going to be challenges. And that's what has complicated. We have a unique model in the country, and that's what has complicated the entire process. The moment you say that I am going to bring in a CGST and an SGST, that law becomes state specific, and that's where when you have two states, the disputes which we talk about start coming in. What happens when the supply originates in one state and ends up in another state? And that's where we brought in a very unique concept, a concept called IGST, an integrated GST. So this is a broadly explains the journey of the 10 years. We started and sowed the seeds of saying one nation, one tax, and this is what media keeps on flashing over a period of time. But whether this is actually true, as tax professionals we know that it's not really true. What we said was, because of the states and the multiplicity of states in the country, we cannot have a single GST, we will have a dual GST, which means that if the transaction is within a state, that state, there will be two taxes, one CGST which goes to the central government, another SGST which is taken by the specific state. And as I was highlighting, moment you have a state component, there is always going to be a challenge of what happens when there is a transaction which flows across two states. And that's where we innovatively coined a term called IGST. It's an integrated GST. The rate of IGST would be equivalent to the CGST plus SGST. So for understanding purpose, if your CGST is going to be 10%, SGST is going to be 10%, then your IGST will be 20, which is the aggregate of the two. And we brought a unique concept wherein we say that this IGST will be taken by the destination state. The state component of the IGST will flow to the destination state. There's an interesting settlement mechanism also for which has been prescribed for the said purpose. But essentially, when you try to bring in these three concepts, CGST, SGST and IGST, starts the basic challenge. You then end up defining the state boundaries, and especially in services, and this is where you find a major challenge coming up. In services, you typically today have a centralized registration. Moving forward, because you have a C, S and an I component, you are actually fragmenting the country and saying that if I am providing services from multiple states, I will be required to register in each of those states and maintain records accordingly and file records accordingly. So in essence, perhaps we are trying to fragment the entire country into different states, and it's really no longer one nation, one tax. And I think this has been the biggest concern moment the GST law has been notified or thrown for public comments. This has been one of the biggest concerns which people have had. That are we really trying to increase the paperwork? And one rough estimate which we did was to say that a service provider having a single centralized registration today has 2 returns to be filed in a year and 12 taxes to be paid. Moving forward, if he has a pan-India presence, he is going to end up filing somewhere around 700 uploadings in a year instead of 2 returns in a year. That's the level of increase in the compliances which we are looking at. Because every month there will be 3 uploadings, One is an uploading of outward supply, another uploading of inward supply, and thereafter there will be a return. So that's where the larger challenge lies. So with that little bit of a background, yes, there is a challenge which does exist, but at the same time, this is the only way we could have moved forward, and that's why, as a grand compromise, which I keep on telling, we ended up in a situation of bringing in a GST, which is a dual GST. So let's look at what this dual GST is all about. And all of us are aware, on 16th of June, we had a model GST law. Mr. Krishnan rightly pointed out, there's nothing model about it, and it's all sort of a amalgam of three existing laws, three principal tax laws, which being the excise law, the service tax law, and the VAT law. What we try to do is we try to prepare a sort of a bird's eye view of the law in this singular slide, and then we'll go into the topic per se which has been allotted to me, which is the levy and the supply. So essentially this is GST, and we talked about the three fragments of GST. Because of the dual concept, we have the CGST, SGST, and the IGST. And necessarily, once you have three taxes, you have the question of how the credits will get adjusted. So there are rules relating to that. Some person will be talking about it. That GST is ideally levied and collected in the manner specified. And of course, there is an amount. And this is an interesting thing. So at the outset only, there is a distinction between GST and an amount. Now, what is this amount? Now, those a lot of us are from the service tax background. We may not immediately appreciate the difference between GST and amount, because we have always been used to service tax as one singular thing. But under VAT regime, we have a concept called amount. We have a concept called composition, and composition is always treated as an amount in lieu of tax. It's never treated as a tax in itself. So the same principle we are trying to bring in here. We are told that yes, for the mid-sized assessees, we have a small assessee up to 10 lakhs. Between 10 lakhs to 50 lakhs is what we say is our mid-sized assessees, for whom we do not expect them to do lots of paperwork, and for them we will give a composition option. For that we have an amount. So GST is the tax and an amount. So either you can be in a composition scheme or you can be in the normal scheme, which is the tax. And that tax is levied on supply, which we will go into in some time, and collected in the manner prescribed. So, collected from whom? We have a casual taxable person, which includes a casual taxable person, a non-resident taxable person, government in certain cases, but not in case of exempted activities. So, there is a very specific mechanism of collection which has been defined, which again is unique over here. It is borrowed from the VAT regime and not from the service tax regime. So, at various places we will find situations of certain provisions borrowed from VAT regime, certain provisions borrowed from service tax regime, certain provisions coming from the excise regime, and I'll try to highlight each of them. But of course, essentially the question is, what is GST on? And that's where we have the concept. We say income tax is on income, service tax is on service, GST is on a word known as supply. And that's why we say supply is the heart of the entire provisions, and that's what we'll be spending a lot of time trying to understand. I'm not sure whether I'll be able to explain in the entire manner, and of course this is again going to be evolving field, and we'll see lots of variations and thought processes which keep on coming on this. So we have supply on which you will be paying a GST at the rate which is prescribed, and of course that supply has various dimensions to it, starting from the nature of supply, which can be either in the nature of goods or services. There will be a time of supply, the time when you are required to pay the tax, something similar to the point of taxation rules. A place of supply, the place where the tax has to ultimately flow, and the value of that supply on which you are going to pay the GST. And then you have a whole set of procedures which of course include the GST network, the return filings, the uploadings, the payment of taxes, TDSs, all of them to effectuate this larger aspect of tax on supply. So this, I think, friends, is a broad outline of how the GST draft law looks like. Now what I try to anchor is of course the model SGST and the CGST laws. IGST law is a sort of a small law which is an overriding law to define the place of supply and define the principles of defining something to be an interstate supply vis-a-vis the intrastate supply. And with that background, let's straight away go into the most important section of any tax law, and that is the levy provision. So what is the levy provision? Let's read it out together. Section 7(1) of the CA or the SGST Act says, there shall be levied a tax for the CGST or the SGST on all intrastate supplies. Now this is an important word. We are now bringing in some jargons. We are saying there is an intrastate supply of goods and or services. So good. We are now not going to define manufacture of goods, sale of goods, provision of service. It's comprehensive. We are told goods and or services. It's very comprehensive. But what is the tax on? It's a tax on intrastate supply. At the rate specified in a schedule, so you will have something like a central excise tariff coming in, wherein against each product or service there will be a rate which will be defined to this act and collected in such manner as may be prescribed. So this is your charging provision, the levy, which says that there will be a tax or C or an S. So basically it's a combination of CGST under the CGST Act and SGST under the SGST Act on all intrastate supplies. So at some point of time we have to understand what is intrastate, but before we go into that, let's quickly understand a fundamental aspect from this levy provision. Of course, IGST law also has a similar provision, but it talks about, instead of intrastate, it talks about interstate. As of today, we already have 3 important laws in our domain and we are all used to those laws. And so let's quickly try to compare those 3 laws and then try to look at this animal called supply. I will not even go into the definition. But even without going into the definition, let's try to understand what would supply encompass. So when you look at excise, and we are used to this excise law, we say a manufacture is an activity driven thing. It's an activity. Somebody can manufacture. Somebody can manufacture in isolation. There need not be a buyer for an activity of manufacture. And we know various examples wherein we say if somebody manufactures products and does not sell it, throws away the products, it goes waste. Even then there have been controversies in the past that the moment there is a manufacture, the Central Excise Authority demands excise duty. If they say, I don't care whether you are going to sell it, I don't care whether you are going to burn it, I don't care whether you are going to use it captively for some other activity, I don't care whether you are distributing it free. What I am looking at is only this word manufacture. Moment there is an activity of manufacture, there is a raw material which has gone into a machine and a final product which has come out, there will be an excise duty. I think all of us are very clear on this. So that's how excise looks at it. Now compare that with VAT. When you look at a VAT, we say it's a tax on sale of goods. And we have plethora of decisions which says that when you say that there is a sale of goods, there has to be a transfer of goods by one person to another. There has to be another person paying some monetary consideration for it. And necessarily it means that there have to be 2 persons. And therefore we say, when you look at sale or VAT, we look at this type of a matrix. We say there has to be a cross flow. There has to be a flow of goods from one person to another, which also should technically be a transfer of goods and not just anything else. And that's why we had this entire controversy of deemed sales coming in. So there's a flow of goods from one side to the other, and there has to be a consideration from the other side to the first side. Then only there can be a sale, and then only there can be a VAT. And that's the reason why when you compare excise and VAT, you find that in excise MRP based taxation is very routine. But in VAT, when they tried to introduce an MRP based taxation, the Supreme Court frowned upon it. Supreme Court said the sales tax law cannot deviate. There was a provision in the Act created to demand a VAT on sale of medicines at an MRP. And this was being challenged, and in the Supreme Court said that no, sales tax or VAT is a transaction driven tax. Being a transaction driven tax, it can anchor itself only to a consideration. If there is no consideration, there cannot be any tax. And you cannot tax something which is not a consideration. So they said, if the money exchanging hand is, let's say, 500, but the MRP is 800, you cannot tax 800 in any fashion under the sales tax law. So that is what we look at sales tax. Now we come to service tax, which is what is very close to a lot of us. And today we have a definition of service. Till 2012 we didn't have. Thereafter we brought a definition of service, which also says activity carried out by a person to another for a consideration. So even when you look at a service tax law, we say there has to be a service provider, there has to be a consumer of that service or a buyer of that service. There has to be some activity which the service provider does for the buyer, and there has to be a flow of consideration from the buyer to the service provider. Now we are merging these 3 laws, and we come to GST. And instead of these words, manufacture, sale or service, we now start using the word called supply. So let's reflect on it. We don't go into the definition sense. Let's reflect on it. By its basic understanding, what does supply mean? Is it more like manufacturing, or is it more like sale or service? So you can see VAT and service tax, we have similar principles, but in manufacture we don't have a similar principle. So essentially the question which we are trying to ask is supply an activity or is it a transaction? Right? I hope I am clear or I am confusing. So the answer to this, I would believe, of course one can keep on looking at various perspectives to it, but my thought process would be that when you look at supply would definitely mean the existence of two parties. I cannot supply something to myself. I can manufacture and keep that thing with myself. I cannot sell something to myself. I cannot provide a service to myself. Same way, I cannot supply to myself. And therefore, when you look at supply, there would still be a requirement of two parties. And that's the reason why we say the so-called concept of self-supply ideally cannot exist. Supply always has to be made to a second party. And there are lots of international precedents on this. We'll be going into some of them also at some point of time. So the first proposition which I want to make here is to say it is a requirement that there should be two parties. Now of course, when we look at the definitions, some of the people would say that a definition no longer requires, like service requires activity carried out by a person for another. The technical definition of supply doesn't use this, it just uses by a person. According to me, that does not impact this analysis. The word supply within itself has a requirement. The word supply itself means that there are two parties. There cannot be a situation of supply to myself. There can be a situation of manufacturing for myself. So therefore, that is the first proposition which I would like to lay, that there have to be two parties involved. Supply definitely would mean doing something and there has to be some benefit, and that's an interesting analogy which Mr. Krishnan was explaining, that the person has to do something for me and not against me. Same way, when you look at supply, there has to be something done and that something has to be done for the benefit of the other. That would definitely mean a cross flow of an activity from the supplier to the recipient. And the third part is consideration. That is where we have a challenge. There can be a situation of a person supplying free. So consideration is one area where there can be a challenge, and that's also what Schedule 1 talks about. It says that there can be a supply without a consideration and that could be taxed. So essentially when you look at the macro picture, you would still say that there is a requirement of two parties, there is a requirement of an activity, but maybe to some extent the requirement of consideration gets diluted when we move forward into GST on this front. So that's what we try to put down over here in terms of a table, and there are 4 questions. All of this we will try to discuss it at some point of time. So let's go into the next aspect. Having understood the macro level positioning of supply, let's understand what is this classification between intrastate and interstate, because that's going to be the key. If it is intrastate, you will pay GST plus IGST. If it is interstate, you will pay IGST. So therefore, the entire levy is linked to a transaction being either an intrastate or an interstate supply. Now, what is intrastate and what is interstate? That has been defined under the IGST Act, because under the Constitutional Amendment Bill also, the powers to determine the principles for determining what is interstate and intrastate is provided to the Parliament. And therefore, what is meant to be interstate supply is given by the IGST Act. And therefore, intrastate definition also is under IGST Act. You have to read that Act and then come back to the SGST or the CGST Act accordingly. So what is the broad principle? We are told interstate and intrastate, the distinction will be based on a combination of two parameters: location of supplier and the place of supply. Look at where the supplier is located. Location of supplier is one basket. Look at the place of supply, and essentially, of course, there are specific rules for place of supply. Essentially, we say place of supply is the place where the goods or services get consumed. So, if I am supplying, I am a location, let's say I am a consultant, my location is in Bombay, the location of supplier is Bombay. If my client who is consuming this service is in Bombay, then it becomes an intrastate because the location of supplier and the place of supply is in the same state. If my client is in Calcutta and consumes my service in Calcutta, then it becomes an interstate supply because the location of supplier is in Bombay and the place of supply is Calcutta. So that is how we try to define it. We define it based on the location of supplier and the place of supplier. So let's quickly read it. We are told section 3 of the IGST Act defines interstate supplies. We are told, subject to the provisions of section 5, supply of goods in the course of interstate trade or commerce means any supply where the location of the supplier and the place of supply are in different states. So the emphasis is on different states. Subject to the provisions of section 6, supply of services would be the place where the location of supplier and the place of supply are in different states. So you have subsection 1 which talks about goods, subsection 2 which talks about services, and both of them, the essence is compare the location of supplier with the place of supply. If both of them are in different states, it becomes an IGST transaction. And when I am talking about this, you also need to understand that section 2, there is an explanation which deems import and export transactions to be covered under the IGST Act. And therefore they are also deemed to be interstate supplies. As compared to that, intrastate. Intrastate is location of supplier and place of supplier in the place of supply in the same state, then it becomes an intrastate supply. Again, goods and services, the same thing. So how do we summarize it? Location of supplier and place of supply in the same state, intrastate. Location of supplier and place of supply in different states, interstate. And import and export of goods will be interstate. Now, of course, when you look at this, it appears very simple. But there's one important issue which comes out from this, and which is the fact that when you refer intrastate and interstate, both of them are distinctly defined. Unlike when you look at the definition of goods and services, we have a definition of service which says any supply other than goods, anything other than goods. Therefore, service becomes a residuary definition as compared to goods. Between goods and services, both the definitions are exhaustive, meaning all situations will get covered either under goods or services. But here we have a situation of interstate not defined as anything other than intra, or intrastate not defined as anything other than inter. Therefore, there could be a situation where something is not intra, not inter. This is a little bit tricky to look at. Somebody will say yes, either they are in same state or they are in different states. How can there be a third situation? The third situation can happen because there is a whole set of concepts called union territories. And within union territories, we are having two union territories which have a legislature, and the definition under the IGST Act itself says union territory with legislature will be deemed to be a state. But union territories without legislature are not deemed to be a state. So they are not states. So what happens when supply happens in those areas? What happens when supply takes place in an area which is a part of India but not a part of any state? Because the definition of India is very wide. It includes extended continental shelf. It includes activities which happen on Bombay High. But they are definitely not a part of any state, and we have, in the VAT context, we have had lots of litigation on this front. And courts have held that Bombay High is not a part of any state. Okay, though it might be an extended definition of India, it's still not a part of any state, and therefore VAT is not applicable. We have, of course, there is a controversy, but we already have decisions from Gujarat High Court on this front. So the question which I am trying to bring about is that you can have a situation where there is a transaction which is not destined towards any state. And if a transaction is not destined towards any state, then the entire law fails. It cannot be a C plus SGST, because C plus SGST applies when it is an intrastate sale, and IGST also cannot apply because IGST applies when it is between two different states. Here there is no state only, therefore even IGST cannot apply. And that's what we are trying to bring out over here, and this is a same answer, because firstly it's not a state.
Yeah.
So because while we say the extent of the C and the I law is towards the whole of India, so the extent is wide, but the levy is not. So that is a larger challenge which we are looking at, that what will happen to these types of transactions. Will we therefore look at a situation of small pockets of tax havens springing up in the country? Will the central government bring some type of a legislation for this areas, naturally no states can bring a legislation. The center will have a challenge because the constitutional amendment bill does not permit them to do that. So they would have a challenge in defining some legislation for this type of specified union territories. The GST amendment, constitutional amendment bill only applies to the states with a legislature or union territories with a legislature, because that is defined to be a state. So we have Delhi and Pondicherry, which are union territories with legislature, there the GST will apply. But other places like you have Daman, Silvassa, there is a large challenge which can exist, and even the extended continental shelf. So let's look at this Bombay High example, and there are lots of construction and repair activities which go on at Bombay High. And currently the proposition is that yes, excise and service tax is applicable. There have been lots of notifications in the past in service tax law which have kept on changing to actually include all these territories into the service tax net. Of course, before 2002 they were not covered, and then we had notifications extending them. VAT, there has been a decision from the Gujarat High Court which says that yes, this is not a part of any state, and therefore VAT cannot apply if the sale happens at the Bombay High. And that's where the challenge comes in, that today you have excise service tax applicable, VAT not applicable. Based on the way the law is drafted, you might end up seeing that just like VAT is not applicable, which is equivalent to SGST in future, excise and service tax equivalent to CGST, though it is applicable today, you might end up in a situation that will also have to pave its way, and you might see a situation of the entire GST going away, and therefore these areas perhaps to some extent becoming a sort of a tax haven in that sense. So that is the impact of, make no mistake, I am not suggesting that the extent of the law is not there, but the levy is failing. There is a difference between these two. The CGST Act applies to the whole of India, but the levy is failing, and once the levy fails, the law might be extending to everything, but if there is no levy, then there is no tax. So that's where we end up on this point. So that is as far as the levy is concerned. That takes me to the second important area of discussion, which is the collection. And this is where we find that there is a little bit of a difference between the way the GST law is drafted and the ways the service tax law existed till date. Till date, in service tax law, we never had this concept of dealer or a taxable person. Moment you rendered a service which was a taxable service in the positive list regime, and thereafter not a part of the negative list, you didn't go into any other detail. You just said, okay, there is a service, there is a tax. There might be a basic exemption limit, that's fine. Otherwise, the moment you render a service, you never went into understanding the constitution of the person and deciding whether this person is an eligible person to enter into the service tax law. VAT had this concept. VAT had a concept called dealer. So, just because you sell something doesn't mean you end up paying a VAT. You have to be a dealer. All of us here as professionals understand this. Many of us might be selling old furniture, and some of us might have large sale of furniture exceeding 5 or 10 lakhs rupees of basic limit. Did we ever go up and register with the VAT authorities and pay tax? If we sold more than 10 lakhs of goods? We never did that. Not because we were not compliant, because we never constituted dealer as defined under the VAT law. VAT law has a very specific meaning of a dealer, which is a person who is into a business of selling goods, and then there is a deemed dealer list which includes banks and financial institutions, etc. If you are not fitting within the definition of dealer, even if you sell goods worth more than 10 lakhs, you are not liable to register. You are not required to pay a tax. This type of a concept we are bringing in the GST law. So in GST law, supply is important, but also important is the fact that you have to be a taxable person, because the tax has to be paid by every taxable person. And that's where we need to understand what is this taxable person. We have been given a definition of taxable person by section 9. We are told taxable person means any person who carries on any business at any place in India and who is registered or required to be registered. So the cornerstone of a taxable person revolves around business. And this, I think, is an important aspect of the GST regime. Business is defined, and we will go into the definition of business also in a few minutes. But unless you satisfy this test of business, which may be for a non-pecuniary benefit, because the definition of business includes activities for a non-pecuniary benefit, unless you satisfy this cornerstone of business, you are not a taxable person. You might make a supply, and yet not pay a GST. So that is a sort of a proposition which we are trying to make here. So we have a definition of taxable person, which is defined to mean any person who carries on any business and who is registered or required to be registered. So we have a long list of persons who are required to be registered. Maybe many places it's irrespective of the threshold. So in those cases, necessarily you will have to end up paying a GST. There's a proviso, and our colonial aspect of having provisos, explanations, broken sections, definitions not being reproduced, all of that is there here. So we have a proviso, and that's an interesting proviso. We are told, provided that an agriculturist shall not be considered as a taxable person. Make no mistake. We are told an agriculturist shall not be a taxable person. We are not saying supply of agricultural produce is not a supply. There is a difference between these two. The exclusion is vis-a-vis the person. It is not vis-a-vis the underlying product or the service. And that is one more important variation. Typically, when you look at any service tax law or the VAT law, these are transaction-driven taxes, and most of the times the exemptions or exclusions are provided to the underlying product or the service. But here, we are told an agriculturist has a green signal, he can straight away walk out, he is not into the GST regime at all. Therefore, if there is an agriculturist, and we will go into the definition of agriculturist, but for a moment assume that somebody is an agriculturist and he sells, let us say, a motor car. Will he be required to pay GST? That's a challenge, An agriculturist selling a motor car not required to pay GST, but the grocer at your doorstep selling you agricultural produce in the form of vegetables is not excluded here. There might be an exclusion in the schedule. So the schedule might say vegetables is nil rate, that's another thing. But from the scope he is not excluded. From the scope it's only the agriculturist who is excluded. And I think this is not the right way, and this is one of the representations which we made, that this is not the right way. What you should give an exemption to is a product. You want to give an exemption to agricultural produce? Give. But it shouldn't be vis-a-vis a person. And that's where you see the power of mind which Mr. Krishna was talking about. And that's why you also see RCM. Lawyers saying, okay, we don't want to pay. RBI saying we don't want to pay. Government saying we don't want to pay. So because of that we complicate the law, we bring in the reverse charge mechanism and all those things. At some point of time when GST was talked about, the thought process was RCM may no longer find a place. But when we read the section, and that's where we come to section 7.3 once again, we are told, notwithstanding what is stated above, the government on recommendation of the council may notify certain categories where the tax shall be paid by the person receiving such goods and or services. So essentially 7.3 of the Act enables prescription of reverse charge mechanism. So we are back to square one. We would be having a notification talking about reverse charge mechanism. It would say that GTA, UPay, or just examples, anything can come. I'm sure whatever is there right now would definitely come. Along with that, you might have a laundry list of more items in it. And more importantly, today we have RCM in services. In the VAT law, there is no RCM. But now we are told receiving such goods and or services. So we will incorporate the bad part of service tax into the other area of goods as well. In goods we don't have RCM. There can be certain classes of goods on which RCM can be prescribed. Now essentially RCM is a concept, is a challenge. If it's an international RCM, it's understandable. But domestic, when you have RCM, you are essentially having a situation of an obedient child slapped up with more and more responsibilities just because an disobedient child is not falling in line. Now I think that's the larger challenge. One ray of hope, and that's where I say within challenges we have opportunities. And one ray of hope is to say that here we do not have a concept of partial RCM. That luckily appears to be in the graveyard. We will not have a situation of works contract service where 50% to be paid by the contractor, 50% to be paid by the client, and then again, those types of situations. Here it will be either full tax by the supplier or full tax by the recipient. So in that sense, I think it's a good aspect, at least in this dark cloud, to say that yes, RCM would apply. Coming back to this, of course, we are told agriculturist shall not be a taxable person, and then if you are a small person, you don't need to register. That's fine, and we have that band of 1 lakh where you need a registration but don't need to pay the taxes. We are then told a set of people who will not be treated as taxable persons, and the first one is of course employees. We are told employees will not be treated as taxable persons. But look at the way it is drafted. Now this drafting is a little bit different than the drafting given for agriculturists. Let's read this. We are told following persons shall not be treated as taxable persons. Any person who provides service as an employee to his employer in the course of or in relation to his employment or by any other legal ties creating the relationship of employer and employee as regards working conditions, remunerations, employer's liability. So essentially here the exclusion is narrow. It is vis-a-vis his employment activity only. So while in an agriculturist case I was very confident to say that if I am an agriculturist, even if I sell motor cars I am out, I did not only sell farm produce. Here the situation is a bit different. If I am an employee, my employment services are out because of this exclusion. But as an employee, if I am also doing a part-time consultancy, that consultancy services, that those supplies would clearly be under GST, because here the exclusion is only vis-a-vis his employment activity, not a generic type of an exclusion which has been provided to an employee. Any person who is exclusively dealing in exempted goods is not required to register, and then they are told personal imports up to a particular small limit will be outside the purview of the registration requirement under the GST regime. Of course, we said agriculturist will assume somebody to be agriculturist. Now we go into the definition of agriculturist, and we find that the definition is reasonably narrow. We are told agriculturist means a person who cultivates land personally for the purposes of agriculture. Again, personally is defined that it can be either himself, his family, or by hired labor. And more importantly, agriculture has a very narrow definition. If you read the definition, we are told with its grammatical variations and cognate expressions, includes floriculture, horticulture, etc., but does not include dairy farming, and these are the things which are currently included in the definition of agriculture under the service tax regime. So your dairy farming, poultry farming, stock breeding, all of them will no longer be treated as agricultural products. And that's where you will see a major challenge. You will see your milks and the eggs and the daily supplies which come to you, all of them perhaps coming within the scope of the supply. Maybe a lot of it may be nil rated, that's what we are talking about. Yesterday there was a newspaper article saying that there are around 400 to 500 items which will continue in the zero rate. So if there is a long list of items in the zero rate, we'll have to see. Next week we'll have that out. But yes, right now when you look at the scope of the supply and the scope of the GST coverage, maybe we'll see that yes, there's a lot of things which comes into the GST coverage, and agriculture is very narrowly defined in that sense. So that's the challenge. As far as employees is concerned, we talked about it, the exclusion is POA and activity. That takes me to this concept of deemed taxable person. And we are told the definition of deemed taxable person is given under Schedule 3, and a long list of people, irrespective of the threshold limit, they are required to register. And we have this aspect coming in both from the VAT and the GST and the service tax regime. So for example, today in the CST Act there is no exemption limit. So here also we are told anybody making an interstate supply will be required to register irrespective of the threshold limit, and will be required to pay the GST. Now this is a big challenge even at a professional level. Many a times we have professional colleagues who would be below 10 lakhs today not paying service tax. Now if they are filing a return for one of their friends in Gujarat, you have a challenge, because that 500 rupees becomes an interstate supply. Whatever the small component he gets from his Gujarat client becomes an interstate supply. The threshold limit does not apply. The moment you do a single rupee of an interstate transaction, the threshold limit is not applicable. You are required to register, you are required to pay. And that's where perhaps I come back to my initial slide, wherein we have seen the map getting fragmented. You will find people doing businesses only in specific states. And this was an interesting, just before this seminar, I was at one location, at a client location, and we were just discussing this aspect. That because you are expecting a service provider to obtain registrations in each of the states, the incentive to really go to that state is less. People will look at consolidation. All the call centers, people will say, let me be at an industrial area where I can get good quality of labor, and perhaps that is where this entire concept of fragmentation will be a challenge, and you'll find situations of some states becoming more powerful and more activities in those states and concentration in those states as compared to some other states. So that is a possibility. So irrespective of threshold limit, we are told any person making an interstate supply, same way any person required to pay tax under RCM. Now naturally, we are more or less sure that goods transport agency will be asked. So moment you have this in service tax also, we've seen that the threshold limit is really useless, because if you even have one transaction of GTA, you are required to register and there is no threshold applicable for that. Similar challenge will exist here also, and therefore really the threshold limit, even the 10 to 25, whatever it becomes, perhaps to some extent may become a eyewash. Non-resident taxable persons, casual taxable persons, we have e-commerce operators who will be required to be paying, be covered under the threshold limit, and any person who supplies goods through the e-commerce operator, they also will be covered here. So again, there's going to be some challenge on that front. Persons who are required to deduct tax at source, input service distributors and agents, all of them would be under the deemed taxable person definition and would be required to be under the purview of the GST registration. So what we are basically trying to talk about till now is, we have talked about levy, we have talked about the classification between interstate and intrastate, and then we've gone into the concept of collection and the registration, which is basically a taxable person definition. Now we come to the real heart of GST. We kept on saying that GST is payable if there is a supply, and therefore let's go to the technical definition of supply.
So one question.
Yeah, please.
If a person sitting in Mumbai,
Yes.
buying services say in 20 states of India, in 5 states, not 20 states.
No, very important question. I think that this is where there is a lot of confusion. The registration is dependent on the location of the supplier. So you are a supplier. The first question which you have to ask is, how many locations do you have? If you have an office only in Maharashtra, you might have clients across 30 states. You still need one registration. The money will flow to 30 states through a back-end settlement mechanism. You will still have one registration, paying tax at one place, maybe C, G and I separate codes, just like you have education cess and all are separate codes. You will pay tax under separate codes. You will define where the tax has to flow, and through the settlement mechanism the tax will flow. You don't need multiple registrations if you have only one branch or one address. Challenge is if you have 3 or 4 addresses or 3 or 4 places from where you make the supply. That is where the challenge starts. That in those situations you will need registrations in each of those places, because you are providing